Welcome back to Pace Immigration, paceimmigration.com, talking once again with immigration lawyer Vince Lalonde. Vince, good to see you.
You too, Sean.
Today, talking about delays. That seems to be the topic du jour, I guess the topic of the year when it comes to Canadian immigration, whether it's people trying to get a passport, people trying to get their applications for citizenship or permanent residency through. Apparently, the backlog is up in the hundreds of thousands, if not into the millions.
Yeah.
And what say you, Vince, really quickly, just about all this delay stuff? What's going on?
It's really frustrating. And that's exactly why we're doing this video, as a kind of a response to all this frustration. Clients are stuck in limbo. They're stuck in immigration limbo. They're tired of waiting endlessly without any information or updates. A lot of the time their consultants are telling them that there's nothing that can be done. So the writ of mandamus is a possible solution. There are other solutions as well, possible solutions, but it's really it's just an overall sense of frustration out there. And we just want to let people know that maybe there are some options depending on your circumstances.
Right. I mean, you're always working for people trying to get their stuff done. It's equally frustrating for you as the representative trying to get someone on the phone or get things through in a timely manner. Let's talk about the writ of mandamus. I was talking with Michael O'Rourke, another lawyer at Pace, and when he said writ of mandamus, it almost sounded like some kind of a Game of Thrones thing or something, but it actually is a real thing. It does work. It does exist. Let's talk about it.
Yeah, so it's an effective legal tool. If you have been waiting a long time, as I mentioned, for your application to be processed, it could be used under the right circumstances. Mandamus is actually a Latin term for weak command. And basically what it is you're seeking a court order to force a government officer or a lower court or a public authority to take action, to execute their duty. They have a duty to perform, and you're asking the court to force them to perform their duty. So in the immigration context, what you would be doing is you'd be seeking an order for IRCC to make a decision on your case within a specified period of time. So like normally when you go to court, when you sue somebody, you're asking for money. That's the normal remedy. But in the case of mandamus, you're not asking for money, you're asking for action. You're asking the court to force a government body or a government authority to take action.
Right. And the key word there that you used, you said time and maybe delays in there. And that's where the mandamus comes into effect. But first, let's touch on what it can be used for. You said immigration as well as other contexts, but inside immigration, it can apply to all of these application types.
Yeah, that's right. Yeah. So pretty much any type of application, mandamus is a possible remedy. So permanent residence applications, temporary residence applications, so study permits or work permits, citizenship, TRPs, criminal rehabilitation, pretty much anything. It's not perfectly suited to cases where the minister has a lot of discretion. For example, an H&C application where you're asking the minister to exercise his or her discretion and to make a grant of permanent residence. But even in that situation, it could be used depending on the circumstances.
Okay, so the upshot is that the writ of mandamus is for the government official to get their act together. So the court's going to tell them, hey, get a move on. Let's look at the legal criteria behind it. We've got some legalese slides coming up for those that want to get down to the minutia. But these are the two key points here.
Yeah, so I'm going to go through these. So there is a test, obviously, and so we'll have to look at the circumstances of your situation and make sure that it fits into this legal test that's been laid out by the courts. I'm not going to go through all of these, but if you look at them, it's quite clear that because mandamus is not just for immigration, it can be used in other situations as well. But you can see that it's very suitable in the immigration context. So number one, there must be a public legal duty to act. So with an immigration application, yes, there is a public legal duty for the government to act. So the government can't say, okay, well, we're going to review this, and this application, and these two we're not going to bother with, and we're just going to throw them out. Whenever you submit an immigration application, the officer has a duty to make a decision on your application, either refuse it or approve it. We have to confirm that a reasonable amount of time for processing has passed. So we'll look at the average processing time. As probably a lot of you know, who are watching this video, the government posts that information online. They say what the average processing time is today. So we'll look at the average processing time today. We'll also look at the average processing time, what it was when you submitted your application. And if we see that, this is in excess of the average, okay, then you might be able to use mandamus. Okay, but we'll also look at whether there's any kind of reasonable delay. Okay, whether the amount of time that has passed, the delay has been reasonable. So there are situations in which the delay might be considered reasonable. For example, you submitted an application, but you didn't include everything in there. There was stuff missing, or there was documentation that wasn't prepared properly, or maybe there's just a question about your background. You were, at one point you were a spy for XY government, and they have to do a background check on you. Okay, in those situations, the courts would probably say, yes, there has been a delay, but the delay is reasonable under the circumstances. So we have to look at whether it's been a delay and whether that delay is reasonable or not.
What happens if they just, they might say, look, during the COVID pandemic and the lockdowns, we were short-staffed or people couldn't get to work, and they use that as an excuse, and it might be a reasonable one, but an excuse for the delay, and that's what's caused this backlog to get into the millions. How much do you think the courts are going to let them get away with? Well, how long can that delay last if you're going to blame it on COVID?
They will look at that, definitely, but that's one of the reasons that we look at the average processing time, because we can still see whether, despite the pandemic, whether your application has taken longer to process than other applications that were also submitted in the middle of the pandemic. So yeah, that's probably an argument that the government would try to use, but because we are looking at your application compared to other applications that were submitted at the same time. And if we determine that there's been an unreasonable delay, if it's a delay of a month, maybe the average processing time is 16 months and you're at 17 and a half months, that's probably not a situation in which we would recommend seeking a mandamus remedy. But, we look at all the circumstances, and if it makes sense, then yeah, we can definitely go down this route.
Okay, let's take a look at the process itself. Take us through this.
Yeah, so the first thing we'll do is we'll send a letter to IRCC demanding that they take action on your application. Okay, we kind of give them an opportunity to make a decision before we go down the route of actually applying to federal court. Okay, usually we always will give them a set period of time in which they have to reply to our letter. Okay, maybe 30 days or 60 days, depending on the circumstances. We'll often give them 2 letters. We'll give them a first chance, a second chance. If it's radio silence, they don't reply to our demand letter at all, then the next step is going to be to apply to federal court, okay, for the writ of mandamus. If the court agrees with us, the judge will order IRCC to finalize the application within a certain period of time, like let's say 30 days. Okay, but keep in mind, they're not ordering IRCC to approve your application. They're ordering IRCC to finalize the application. So it could be an approval or it could be a refusal. Okay, so that's a risk when we're seeking the writ of mandamus. So before we go down this road at all, we'll definitely look at your case and we'll make sure that it is on really solid footing before we go this way, because you don't want to go through all the time and expense of applying to federal court for mandamus and then your case is refused at the end of the day.
I was going to say, yeah, I think people have been reading online, because this has become a little bit popular even south of the border as well with the writ of mandamus. People seem to be thinking that it's going to lead to a positive result. This is absolutely neutral. You're just trying to get the court to make a decision. That doesn't mean the decision is going to be in your favor. That's
right. Yeah. You're forcing them to take action, and take action in this situation means make a decision. So it could be a negative decision. So we really want to look at your case and make sure that it's a solid case, that there's no problems with the application or potential problems before we go down this road.
One interesting point that you sent to me in the email, which is where we get these slides from, we email each other back and forth. We've got here that the IRCC has the right to respond in court, but to avoid a hearing, the Department of Justice may just ask to settle the case.
Yeah. So so the IRCC has a couple of outs here. They have a couple of opportunities because like nobody really wants to proceed to a hearing in federal court. Okay. So IRCC, first of all, when they received that demand letter, I said we're going to send them a letter at the outset. When they receive that letter, they have the opportunity to make a decision on your case. If they agree, basically, whether they say, okay, yes, it's true, there has been an unreasonable delay, then sometimes they'll just make a decision at that time. Okay, we don't have to go down this road. We don't have to make an application to federal court at all. Okay, but even if we get to the stage where we have to make an application to federal court, okay, the government, the IRCC still has an out. Okay, so sometimes the DOJ, the Department of Justice, will simply ask IRCC to settle, okay, and issue a decision. Okay, so, and, you know, like I said, nobody really wants to go to court at the end of the day. So we'll see how far along we get in this process. But obviously, it's best for everyone if we can get this resolved as soon as possible. And, you know, we don't want to go to court. We want the government to make a decision on your case.
Right. I mean, and there's tons of people out there in this situation. I'm sure there's a lot of people that wouldn't mind just, you know, letting push come to shove and just getting the decision. You know, as soon as possible.
And there are other possible, I mean, mandamus is a little bit of a last resort. It's a fairly long process, like from beginning to end. It could take a year in itself. So we'll look at the type of application. There might be other possible solutions. I mean, one of the first things we'll do is we'll make an application under the Access to Information and Privacy Act to get a copy of the notes on your case. And we'll see if there's any other potential issues there that can be resolved without going down this road. But if at the end of the day, there's nothing else, there's nothing wrong with your case, everything's fine, and there's a delay anyways, then yeah, this is a possible solution.
Okay, great. Thanks, Vince. You can contact Vince at vlalonde@pacelawfirm.com for a writ of mandamus or any other kind of legal advice when it comes to immigration. Vince, we'll talk to you soon.
Sounds good, Sean. Thank you.
Bye-bye.